Pleasure to welcome back to the program Astra Taylor. She's the co-founder of the Debt Collective, author of her most recent book, Remake the World, Essays, Reflections, and Rebellions. Astra, welcome back.
Thanks for having me.
All right, so today, maybe it was yesterday, I guess, the Biden administration announced that they are going to extend the existing, I guess, under the auspices of COVID, moratorium on student loan debt repayment for everybody until at least, I guess it would end in June, and then 60 days later of 2023, payments would come in. That is supposed to be timed until after the Supreme Court can address the appeal from the administration on two different court cases. Just walk us through briefly those two different court cases, and then, the claims that are made in those court cases, the problem with those court cases, and then we'll talk about the question of the authority under which the Biden administration has issued the debt forgiveness, $10,000 for each student, or I should say borrower, $20,000 if you had a Pell Grant.
Yes. So I think first we want to parse the announcement from yesterday because it is contingent on multiple factors. And that is actually an unusual thing for the federal government to do, to say contingent on action from the court. So the premise is student debt payments will be turned back on 60 days after three things, one of three things. The Supreme Court rules, or debt is canceled, or June 30th. And whatever comes sooner, it will, the payments will turn on 60 days after that. Okay. In my opinion, it should have been whatever happens the latest, let people plan, or just give a firm date. Because again, what's so hard for these, for the millions of debtors out there is, planning your life and knowing how much money is coming in and having that long-term ability to manage your manage your own household budget. So, what is very important about this, though, is that 60 days after the Supreme Court rules means that those are 60 days where payments are paused, where the Biden administration could use one of the other legal authorities that has to cancel student debt. Right now, these cases that you mentioned are focused on the current plan from the administration, which was based on one authority. Again, there are many. The Department of Education cancels student debt all the time through various programs and through various legal bases. This is not unusual. This is not a radical act. They're taking issue with the specific authority that the Biden administration invoked for this, which is called the HEROES Authority. It's from 2003. And essentially it says the Department of Education has the ability in periods of crises, in national emergencies, a la COVID, to relieve student debt burdens for people. So it is this specific pandemic-connected authority that is in question. It is important to understand that this legal authority is clear. What the Biden administration did is absolutely legal. And I want to take a moment to savor how ridiculous and offensive these lawsuits are. So the one that is specifically spurring them to appeal to the Supreme Court, hardly a place that should be having the final word on this issue. This is the Supreme Court that has recently attacked bodily autonomy and rolled back abortion rights, is trashing the EPA and our ability to regulate the environment, right? It should not have the last word. But the case that is causing them to seek their judgment was instigated by 6 Republican-led states who basically said that a student loan servicer, a company called Mohila, which is based in Missouri, Mohila stands for Missouri, blah, blah, blah. It's a loan servicer based in Missouri, will lose revenue under the Biden administration's plan, right? The profits of this company will be harmed by canceling debt for borrowers. Representative Cori Bush, who is from Missouri, wrote a letter to Mohila clarifying their position, and they sent a formal letter back saying, we have nothing to do with this litigation. This is not true. This is so essentially, pulling the rug out of from under this bogus legal argument. Nevertheless, the case is going. And so it's also important to say that a lower court dismissed this case for lack of standing, saying, look, this is ridiculous. This isn't a real case. Nobody is actually being harmed by student debt cancellation. It was appealed up to the Eighth Circuit, where there were 3 Republican judges, 2 appointed by Trump, 1 appointed by George W. Bush. So this case is ridiculous and should be dismissed. Another major piece of litigation out of Texas, which vacated the program, is equally offensive. Again, a Trump-appointed judge, very ideological. And this is the case teed up right with the Fifth Circuit, which is called, Elizabeth Warren called it the go-to court for conservative lawyers. And this case is brought about by a group calling themselves the Job Creators Network. It's actually a billionaire-backed front group that pretends to speak for small businesses. Guess who the main funder is? Bernard Marcus, the co-founder of Home Depot, who's a right-wing oligarch. It's also funded by Mercer Foundation family money, right? The Mercer family. Claiming to speak for small businesses, they found 2 eager plaintiffs who the argument they're giving is one of them's only eligible for $10,000 of relief. One of them has FFEL loans and so isn't eligible for cancellation under this program. They're saying, well, we're not getting the full benefits of this cancellation, so we want to sue to block it for everybody. And they have succeeded. So they're saying we're being harmed because we didn't get enough debt cancellation. Therefore, we will partner with these reactionary billionaires, kill the program, and tee it up again with that Fifth Circuit, who we know will probably do more damage. So that's why these are so bunk and why we need to explore other options.
All right, let me, and just one thing I'm unclear on, in the first case, right? I mean, there's a real question of standing there, particularly when the supposed these attorney generals are supposedly representing the interests of a company that has in no way made any claim anyways. So there's a real question of standing there. In the second case, I mean, maybe the standing is arguable, but none of these cases, it seems to me, have questioned the authority. It seems like that the judge in Texas basically took upon himself to question the authority, as opposed to addressing what the plaintiffs are arguing, which is that we're not getting enough relief. Instead, the judge took it upon himself to unilaterally decide, well, I'm going to go beyond the scope of what the question is before me and ask whether the statute authorizes any of this anyways, never mind whether it's been applied properly. And he's gone past and I think this audience is somewhat familiar with the demise of the Chevron doctrine, which says that the court, and we're not quite there yet, but that courts usually defer when you have an ambiguity in a statute. The HEROES Act says, if you're in some way impacted by an emergency, then the Department of Education has the ability to relieve some of this debt. To the extent that, how much of an emergency it needs to be. I mean, 9/11 happened in a half a day. The implications may have resonated, and that's why the HEROES Act existed. COVID happened, depending on how you want to measure it, months, maybe years, and how you want to measure what the impact is. I mean, there's a certain amount of vagueness. The Chevron doctrine usually allows agencies to deal with that. This guy in Texas decided to use the major questions doctrine, made up doctrine, didn't exist 10 years ago or 11 years ago, literally didn't, made up from whole cloth. He decides to apply that to a question that wasn't even raised, it seems to me. But be that as it may, that's where we're at this point. And the DOJ is asking the Supreme Court to address this on what grounds? What argument are they basically saying the Eighth Circuit, there's no standing, and in Texas, how are they attacking these claims?
Yeah, I think that they are going to go hard against the question of standing in the case that involved Mohila, the loan servicer. And again, the lower court was very clear about this, and dismissed it outright for that reason, and saying, look, there's no basis for harm for having that legal standing to bring this case. In Texas, the judge said, some paradoxical things. So one complaint from these plaintiffs was not just that we didn't get enough debt relief, but it's also that we were denied the ability to participate in a period where we would be able to comment, right? And this HEROES Act, this emergency provision, does not require any notice and comment period, right? So they're complaining about something that this rule explicitly doesn't require. And in the judge's very brief opinion, he kind of contradicts himself and acknowledges that. He's like, well, they didn't get to have this, the chance to comment on the laws, and it's also, but also it doesn't require that. And so it's quite a bizarre argument, which is why legal experts have said this is a logical pretzel. This is judicial overreach. And this person is essentially trying to litigate, create law, to legislate from the bench, which is incredibly alarming. And so this is why, I think we do have to put this whole fiasco, in the perspective of the right-wing takeover of the courts over the last 40 odd decades, probably longer than that, and really ask what this means for progressive movements writ large, because it ultimately is about so much more than student debt cancellation. And, it's very important to say, this is, actually, we cannot just all roll over based on whatever the Supreme Court decides in the society anymore, especially again, when there are all of these other legal avenues available. We're talking about something very, very mundane. We are talking about student debt cancellations. What will this mean for bigger fights ahead?
Well, do you have optimism at all, given Amy Coney Barrett's reluctance to hear those first two cases where she just essentially shot them down? I mean, it seemed maybe I'm looking for silver linings where there are none, but what's the sense of maybe the court's posture towards this?
Yeah, I don't know. I'm definitely, not privy to any of the rationale that went into her refusing to see two previous lawsuits. It could have been that she was holding out for something that, in her mind was more credible. I do think, one thing that has been raised is that the conservative courts might not want to assent to these cases simply because they create such an open platform for standing. And it has been actually conservative legal scholars who for decades have said, no, unless you have personally, lost, a significant amount of revenue from, an environmental disaster or, a car accident or something, you don't have legal standing. Sorry. So these people, they cannot prove any monetary damages. They really have no basis for suing. And, it is actually, the conservative legal world that has been pushing to restrict standing. So it could be, that in some sort of twisted sense of their own sort of broader ideological self-interest, that they don't want to deal with these cases, not because they're on our side or because of any sense of justice.
That's a fascinating point. I should just say, we cover a lot of tort cases. And one of the themes that have been happening over the past 10, 15, 20 years really is the Supreme Court basically shutting the door to the courthouse to a lot of claims across the board, saying you don't have standing here, so that you can't bring suits against government agencies, but also more primarily like even corporations. So that's the situation. We have no way of predicting. If I had to guess, based upon what I know of this court, they're going to find anything that they want to shoot it down. It's basically they start with the policy outcome, and then they reverse engineer it, as this judge in Texas did. There are some who claim that the use of this authority is indicative of the desire of the Biden administration to not actually relieve this debt. Talk about that a little bit, because I think it's clear. I mean, it's clear to me that the use of this authority was, there is a reluctance. I'm not surprised by it. I would imagine by the Biden administration, as there was there's a reluctance by the Biden administration to make the authority to do this explicit and open-ended, because once you do 10,000 or 20,000 under an authority that is not in any way temporally or conditioned, then it creates more political pressure going forward to do this more often, right? I mean, if we're 10 years out from an emergency from COVID, you know, the authority that's used is not going to be used again, presumably, to cancel student debt. But if there's an explicit acknowledgement that the authority exists there since 1935, the act at, you know, from 35, I can't remember what it was now. It was you would know better than I.
Actually, the 1965 Higher Education
Act. Then that pressure can exist going forward. So talk about that dynamic there.
Yeah. What's interesting, I mean, again, there are a range of legal authorities that can be used to cancel student debt. So the Debt Collective has been pushing for the last few years to have the president cancel student debt using the authority granted by the Higher Education Act of 1965, which is a very broad authority. But much of our organizing has focused on students who were defrauded by predatory for-profit colleges, and we brought to light something called borrower defense to repayment that says if your school broke state law that you're entitled to debt discharges. So that's how we've won billions and billions of dollars in this year alone for student debtors. There are other legal bases. People get debt forgiveness, as they call it, through income-driven repayment plans, through public service loan forgiveness. Again, this is not radical. But yes, I think there was absolutely an intention in the Biden administration not to use an authority that would be impossible, right? This wasn't them, sort of saying
some nefarious plan.
Actually, right. It wasn't nefarious in that way. It was nefarious in the sense that they wanted to say, this is limited. This is about the pandemic, because they're not willing. They're neoliberals. They're not willing to say education is a public good. We should cancel all this student debt. It's all immoral, and make college free for everybody. Right. That's what they're afraid of. They're the bigger framework movement that will push them to do it again and again. But the genie's out of the bottle. Debt's been canceled many, many times. We all know it can be canceled again and again. So, they were fighting in that sense a losing battle. The real mistake they made is not the legal basis is important, but it actually was that they moved slowly. So advocates, including, the Debt Collective, who are kind of on the militant wing of things, but a lot of allies who are much more, traditional, were very clear with the administration. You need to not have an application process. You need to not limit relief based on an income cap, because doing that necessitates an application, and you need to move swiftly. So they took 6 weeks to release an application that was essentially a glorified Google document that cost the government $100 million to make, and every day bought their enemies time. And again, we are talking about lawsuits funded by billionaires the Cato Institute had a lawsuit. They filed them in the perfect, courts, teeing them up with the judges who will be sympathetic. They have deep, deep, deep pockets to do this, to find someone willing to say, yes, exactly as you said, to reverse engineer that policy ambition they have. And that was the mistake that I am incredibly angry about, was delaying when we should be governing, the big we, the big tent that includes the Biden administration. Not that they want much to do with me, and definitely don't take my advice, but in knowing what we're up against, which is Republicans and right-wing, oligarchs who will do everything they can to stymie even a base, a moat of a relief for working people. And so it was that slowness and that delay that really did this. And it's clear. So the last thing I'll say on this is, in the hearings for these legal cases, the right-wing plaintiffs, the lawyers were clear that if cancellation had just been done automatically and quickly, they could never claw it back. There's no way. They were like, thank God this is so long, because now we can stop it. So there are lessons here. One is, and maybe the most important one is, do your policy like you mean it. Words and deeds simultaneously.
There's two analogies that come to mind with this situation. One is that during in the American Rescue Act, they, instead of expanding Medicare to provide for health insurance people, they did it through COBRA. So, I mean, and they provided free COBRA. If you're getting health insurance during that period of time, it is free to you. From the perspective of somebody who's wants the material benefits of health insurance during that time, it was free to you. It was much more expensive for the U.S. government to do, but they did not want to set that precedent that you could expand Medicare. Because once you expand it once, people are like, hey, wait a second, why don't we continue to have that? Or at least they're afraid of people asking that question. And then the second analogy would be in the Build Back Better bill. They should have gone on that much quicker after the American Rescue Act. They should have done it a year earlier instead of slowing things down. Because the one thing I think that we've learned in this context is that, and I think there is a will there by the Biden administration. I don't think it's because of the goodness of their hearts, but I think from a political standpoint, they understood the importance of it to at least give some student debt relief. But I think you're absolutely right. They didn't want to set a precedent that this could be extended and people would get the idea that you could do this at any time. Again, I think that's also a folly on their part as well, because people are, that's the mindset that people have. But they also, like you say, they delayed in this where they could have just said, like, we have all the records. We know who's there. The only reason why they set up this application process, as easy it was, is to sort of say, like, let's see, maybe there's a bunch of people who don't really care about it. And we're talking about 45 million people. If 5 million didn't happen to follow the news or get it, then there's some, I guess, savings or whatnot. It's not as big as people said. And, but they could have done it like 48 hours after Biden announced it, and then facts on the ground. That's it. End of story. Move on to the next thing.
Absolutely. And again, we've seen this movie before. This is why I have a bit of optimism. I wouldn't call it a silver lining, but, optimism of the will. So again, I've worked for years with students of for-profit colleges. We organized the first student debt strike in 2015. The Obama administration trickled relief. Instead, it was well proven. And in fact, the CFPB and other entities validated this. There was systemic fraud. They made every debtor individually prove they had been defrauded, just one by one kind of picked people off. A lot of people didn't know that there was an application to submit, because that's what happens. Actually, the most vulnerable, the most in need of student debt relief often don't know what the process is. So they trickled out this relief. Trump took office. We spent 4 years fighting DeVos to just hold ground. And in June of this year, the Biden administration is basically assented to our demands. The demands we had at the beginning: cancel every penny for all these students automatically, immediately, no application, no delay. And they raised over $6 billion of debt for nearly 600,000 people. So we need to make that happen faster this time around by keeping up the fight and being relentless about, this point that, we cannot govern like it's, 1993 or something.
Right.
And we have some time. We didn't have time then, actually. That's what we know today. We didn't have time then. And we definitely do not have time today.
Do you, I can appreciate why the Biden administration may not be too psyched to talk to you and keep you updated on what they're doing, but do you hear anything through your channels as to like what they're predisposed to do in the event that the Supreme Court says no? I mean, on one hand, like the idea of like punting seems like a bad idea to me. On the other hand, the closer we get to that next election, it seems to me the more pressure there is on them to, at the very least, deliver this, because it was by any way that you could measure, it was at the very least not a political liability whatsoever. And it was more than likely a political benefit. I mean, it seems like for them, in their punting this, they're putting it into play in the next election, and that they're going to need to do this.
Yeah, no, I think this is the thing. They've also sent they sent emails out over the last 48 hours to millions of people saying your application was approved. Yes, it's tied up in the courts. People are counting on this. The President of the United States, the Department of Education have given their word and said, you applied for relief, and we approved you for it. And it was not a political liability. The people who said it was going to be were, let's name some names: Larry Summers, Jason Furman, the neoconservative economist, Matthew Iglesias, saying, oh, this is going to be so horrible. People get their debts canceled. There's going to be this centrist backlash and a right-wing backlash. Oh, to the contrary. A recent poll.
Not even a hair. The thing was, no, and in fact, it wasn't even a 24-hour news cycle, how quickly it went away.
Well, and people loved it. I mean, polling just said 60% of voters under the age of 30 said it was either very important or the only reason they voted. And we're talking about elections that were won by, small margins. And so you could, make a case. The student debt cancellation helped hold the Senate, that helped stem that anticipated red tide. So I think they're really playing with fire by letting people down. The Debt Collective, as we do, is organizing a debt strike and saying, look, you can never turn on payments for debts the President of the United States has promised to cancel. No, we can't pay and we won't pay. And we're going to have to keep fighting. I mean, they've never given a penny of relief out of the goodness of their hearts. Debtors have always had to organize to raise the political stakes. But here the political stakes are clear and they are electoral. This is the, and there's data to back us up. We always said this is going to be a popular thing. People are weighted down by these loans. Generations ago, it was not like this, and people know that. People who don't have student debt have loved ones and friends who have it. This is a popular pocketbook policy. And so I really think the Biden administration, we have leverage to force them to deliver on this, and they have the legal authority to do so. We will not accept a future where a right-wing Supreme Court or these lower courts, full of lifetime appointees put in place by people like Donald Trump, get to decide whether, ultimately whether we live or die. Because this is, again, about more than student debt relief. It's about, the habitability of the environment. So no, we need to govern creatively and figure out how to provide the things people need, to not just survive, but to thrive.
Astra Taylor, co-founder of the Debt Collective. Where can people get more information if they want to in some way help with this pushback?
Debtcollective.org, always and forever, especially, sign up for texting these days since Twitter seems dicey, but we're also on Twitter at @StrikeDebt.
Thanks so much for your time today. Really appreciate it.
Well, thanks so much.